There has not been a major new plant built between Baton Rouge and New Orleans in 15 years. This American Rhine Valley was once a logical siting for chemical firms. Now global competition, labor rates, and widely varying environmental rules overseas offer companies a choice. 8 years ago, Japan's Shintech Corporation chose St. James Parish to build the world's second largest raw plastics plant. St. James Parish is nearly half black, half white. Until yesterday, Shintech wanted to build in Romeville, near Convent. It's majority black. Parish high school graduation rates, 3/4 in the area of the proposed plant. More people are less educated. Unemployment in this industrial river parish, still 11%. Around where the plant would have gone, 62%. So maybe the plant would have done some good, not so fast. What's been the reaction among some residents when they had considered questions of pollution?
I wouldn't even bother to try. I wouldn't even bother to try to do nothing. They ain't asked us for them other plants come up here. They ain't asked us nothing. And what can get that plant worse than the ones they already got? How many explosions they done had at them?
Sometimes they have a warning saying that something has escaped. We got to stay in the house and all that, in the air and all that.
We don't want an apology from the government in 15 years because of the Holocaust that are going on in our communities. This is environmental genocide at its worst.
The citizens group that fought Shintech is made up of ordinary citizens with, they say, ordinary incomes that would not support hiring a lawyer. Last year, they could, however, afford the Tulane Environmental Law Clinic.
That's not good for you, call us.
The clinic is 25 students practicing to be lawyers by practicing law on behalf of people who cannot afford to fight big companies. In the case of Shintech, however, these students took on more than a Japanese plastics firm. They wound up taking on the governor, the Secretary of Economic Development, the Department of Environmental Quality, Chambers of Commerce, and the Louisiana Association of Business and Industry.
What they were trying to do is hold this plant up to the point where it's economically feasible not to come here, and they're going somewhere else, and Louisiana's going to lose a bunch of jobs.
Governor Mike Foster, in an interview for this program, said he would take a look at Tulane's tax-exempt status and called on the school's alumni to review clinic activities.
It's P-I-G-O-T.
This group decides they're going to be the law themselves. It's almost like they are the vigilantes out there doing this on their own, and I don't think it's right.
This summer, business backers asked the state Supreme Court to review the rules under which environmental and other law school clinics operate. In a June decision, the court stunned law students and teachers like Tulane's clinic director, Robert Kuhn.
For 20 years, the clinics have been representing working class families, working poor, people who might not be on public assistance, but surely by no stretch of the imagination do they have the thousands and thousands of dollars lying around to hire attorneys when they get in a legal problem. The new rule severely restricts the individuals that clinics can represent and requires those individuals to demonstrate that they meet the very strictest poverty guidelines in America. And so not only is it not simply a clarification of the rule, it's also a restriction that is more severe than any other state in the country. And on the issue of group representation, for years, clinics have been representing nonprofit community organizations on issues relating to consumer issues, environmental issues, civil rights issues. Never with any problem, clearly within the scope of the rule. And now the court has put a requirement of indigency on the members of the organization such that, quite frankly, I'm not sure whether more than at most 1 or 2 groups in the state might qualify.
Sam LeBlanc heads the Chamber of Commerce for New Orleans and the River region. He says the Supreme Court is merely stressing existing law clinic rules.
For instance, the dean of the Southern Law School has said, we can operate under these rules. So it's become, again, a controversial public relations, publicity, celebrity matter, more than anything else.
Because the clarification that you got really only stressed again what their rules were in the first place, as to what their role was and who they can represent.
That's correct. That is correct.
These rules were on the book.
That is exactly correct. But you have to go and check the record to see. You have to see what was requested and what came out, and nobody's doing that. Nobody who has ever interviewed me has done that. And of course it's not going to be brought up by the law clinics, because if it's brought up by the law clinics, it would quash the controversy. And controversy is what is wanted, unfortunately. Instead of progress in getting people jobs and improving the economic situation in our state and perforce the educational situation, they're satisfied with controversy, to have it on TV, to have it in the newspapers, to keep it going.
While environmentalists decry it all as political kowtowing to industry, a fierce election is underway for a term on the Supreme Court. A 25-year incumbent, Chief Justice Pascal Calagaro, has been a fighter for pro bono representation of indigents and the poor. Curiouser and curiouser, his critics say, is the court's unanimous decision concerning whom the law clinics may represent. Calagaro says if you think the court is buckling down on the clinics, you should see the list of clamps business and industry wanted to employ, but his court denied.
I think they wanted about 10 different propositions considered. One, they would have required balanced representation of government, small business, and environmental interests by student attorneys. No,
Which would obviously be a conflict of interest. You can't
do that. We told them no. They wanted to compel regular communication with the client and representation of the client above those of the student attorney or law clinic, because they suspected there was an agenda in a clinic unrelated to the real disaster. No, we don't make other lawyers come up and tell us how they're communicating with their clients. They wanted to require screening and approval of matters undertaken by law clinics to see to some supervisory group. Well, we said no, the law clinics can handle their own business. They wanted to say that the student would be the primary spokesperson at all hearings and the professor can't open his mouth. No. If you can have adequate representation in a clinical circumstance, the professor can handle the case entirely if he chooses. We turned him down on 7 or 8 different situations. What we did, however, was find that under the rule that existed, there was not, it was simply not being complied with.
I think to suggest that this is just a clarification is not just wrong, it's disingenuous. They knew exactly what they were doing. They were rolling back the availability of legal assistance to working families in the state.
What does it do to your client base when they have to prove their incomes? Because part of the ruling is that 51%, not just a majority, but 51% have to be at a certain federal cutoff for impoverished or indigent incomes.
I think that when we make it a condition of someone to participate in a public debate that they have to reveal their income, we have clearly sent a signal that we don't value community participation, and we have also surely engaged in a requirement now that will chill participation or scare people away. Because you can imagine anyone, if you were thinking of joining an organization for some civic purpose or political purpose or social purpose, and they sent you back a form and said, you know, we'd be glad to have you as a member, but you need to reveal your income to us. I think there are very few people that would then go forward joining that group.
Is it possible there is in this state an alliance between business development, the chamber, and government that doesn't want any obstacles, that doesn't want these students throwing up roadblocks to economic development?
I don't think that in some instances the Tulane Environmental Law Clinic has really gone out to protect the environment. I think they've gone out to make a name for themselves, to stop anything, period, for whatever reason. We did not ever, and I'm going to make this clear, we have never attempted to have any clinic, the Tulane Environmental Law Clinic or any environmental law clinic, stop from having the laws enforced. Never. Quite the contrary. We support that because it's good for everybody. It helps to create jobs. It helps to clean up the environment.
I think that they don't understand two things. One is that the ruling that the Supreme Court issued affects, in the end, all of us, because all of us at some point or other may need an attorney, or all of us at some time or the other surely would identify with someone, whether they're a family member or a friend or a co-worker who also needs a legal assistance and who now can't turn to a clinic. I also think that the thing that isn't being understood is that the ruling of the court is directly contrary to what lawyers are taught. Lawyers are taught...
And swear to do.
And swear to do. Lawyers are taught and swear to try to advance the availability of legal services to those who can't afford it, and to ensure that legal representation is not denied someone simply because they may adopt a position that's unpopular or subject to disapproval. And unfortunately, that's exactly what's been happening in Louisiana.